Good day, my name is Wendell Norkia, and this specific video will look at an overview of international criminal law. So international criminal law is actually very broad. It has four main core crimes, and they are genocide, crimes against humanity, war crimes, and the crime of aggression. Now, under genocide, crimes against humanity, and war crimes, you will also find underlying crimes like murder and rape and other crimes that you can commit as a defendant at the ICC, for example. And the ICC, again, this is not the International Cricket Council, but it is the International Criminal Court, and it is the only permanent international criminal court that we have in the world. So at this court, you will most likely only see the prosecution of individuals who have committed large-scale crimes, and we also say in the academia, atrocities. So this is not an individual who murders 2 or 3 people, but an individual who has allegedly murdered and raped hundreds and even thousands of people. Just to give you an example, the genocide in Rwanda in 1994 is classified as genocide, and this is a core crime of the ICC statute. But at the time, the ICC did not yet exist as a court, so that those crimes were prosecuted, some of them were prosecuted by the International Criminal Tribunal for Rwanda, and also by informal courts, also called gacaca courts, as well as some of the courts throughout Rwanda. In that case, genocide was prosecuted, and it was regulated by the International Criminal Tribunal of Rwanda statute. So all of these courts are creatures of statute. The ICC is regulated by the ICC statute, and usually these statutes are also connected to a certain city where that conference took place, where they deliberated about what must be included in the statute. In the ICC's case, it's called the Rome Statute. But just to come back to Rwanda, so in Rwanda, you had a situation where 900,000 people were murdered in a question of 3 months. So up until this date, it's the largest amount of people who have been murdered and killed within such a short time. It's not comparable to what happened in World War II, of course, where over 20 million people died, but that was over a amount of time of 6-7 years. So what happened in Rwanda in 1994 is a shock to everyone who was alive at that time. And the world, in many respects, US, Australia, UK, even South Africa, we didn't do a lot to prevent those atrocities that took place in Rwanda at the time. So that's what international criminal law is all about, to prevent these types of atrocities. When you look at murder and rape of individuals, and I would not say those are large-scale commission of crimes, it's still very serious in our communities. We don't want it, but that's the responsibility of your local police force. In South Africa's case, it's the South African Police Service that must prevent crime. And of course, we know that that doesn't take place always, and due to staff shortages, due to abuse of power by police officers, police brutality, and just sometimes ignorance. But there are, of course, police officers who do their jobs, but there simply aren't enough good ones to prevent crime. And of course, crime is also due to poverty, unemployment, and various other social economic factors, which must always be addressed by a government. But when we talk about large-scale commission of crimes, we're talking about sometimes thousands of people being allegedly murdered by the specific defendant that is appearing at the ICC. And this is also what happened during World War II. So at World War II, they didn't have the ICC, of course. They had the Criminal Tribunal at Nuremberg, as well as the Criminal Tribunal in Tokyo. And these criminal tribunals are very important to prosecute those most responsible for the crimes that were committed during the atrocities that occurred in Tokyo, as well as the Holocaust that occurred, of course, throughout Europe, which was the responsibility, of course, of the Nazi Party. So at that time, you didn't really have definitions of the crimes that we know today. Genocide wasn't known as such, it wasn't prosecuted as a crime as such. You had still crimes being developed at the time. You had war crimes, crimes against humanity that was still developing, and you had crimes against peace as well, which we today know as aggression. So what happened during World War II, again, also shocked the conscience of the whole entire world. And at the time in 1948, of course, the United Nations also gets established, and the world order decides that we need to take a stance. No more. But as you know, in 2026, we are still saying no more because we see the amount of atrocities being committed throughout the world, in Sudan, in Palestine, in Ukraine, and so forth. And still nothing is being done, because if you are in control of a country, if you are a head of state and you want to commit war against another country, you will do it. You have sovereignty. And who's going to stop you? Because there's no international police force. So it's up to the states to prevent such atrocities. But if a country commits atrocities within its own borders, then sometimes it's very hard to stop. We know all that when we just look at Africa situations, how many civil wars there have been in African countries and how many bloodshed there has been because of that. So international criminal law is not just at this big scale or large scale at this international level, but also within domestic systems too, where your own domestic court, like I'll use South Africa a lot, so African courts can prosecute genocide, war crimes, crimes against humanity and aggression, because we've domesticated the ICC statute in our own laws. So we can prosecute these crimes, and the definitions are within our law. But if we feel that we are not able to prosecute a certain individual who committed a war crime in South Africa, we feel that we don't have the best prosecutors to deal with the situation, we can then approach the ICC and ask the ICC, the International Criminal Court, the prosecution's office, whether they want to investigate this case, and this will then be called the situation of South Africa, and then they will decide whether there's prima facie evidence to lay charges against the specific individual. And then that individual can be transferred to The Hague in the Netherlands, where the ICC is, and that individual can be prosecuted at the ICC and most likely be returned back to South Africa to serve his sentence, or stay in the Netherlands to serve his sentence there. That is just how, like, one example of how the ICC can help states. And then what can also happen in international criminal law is you can have hybrid tribunals being set up within states. So the court, for example, when you look at the ICTY and the ICTR, they had courts within Rwanda. They had an international court within the former Yugoslavia. That, although the Yugoslavia court was actually in The Hague, but the one in Rwanda was also not in Rwanda, but it was in Ethiopia. Those courts, they were closer to the crimes, whereas the ICC's court is far away from some of the crimes that it hears. For example, there's been a few cases at the ICC in terms of crimes that were committed in Uganda, and then some of the victims have to travel very far to go and testify about their experiences during a conflict. So of course this is very traumatic, and then they have to travel far, and this then means that the court isn't able to hear many victims because it's just too expensive to ask 5,000 victims to come to the court. So they also have victim representatives who then puts their story to the court after the victims have spoken to these representatives. So the court is very unique, so I'll focus mostly on the ICC, but also do know that hybrid tribunals can be set up within countries, and they can have a look at the conflict, and they're much closer to the conflict, which makes more sense in a way. And of course, the ICC can only hear so many cases. They don't have 50 judges, they don't have 50 courtrooms, they don't have 150 prosecutors. They only have a certain amount of money. Germany, I believe, is the biggest funder of the court. That's quite interesting because, of course, Germany was responsible for World War II. So Germany, in a way, feels a bit of guilt, and we've seen this over the decades, where they are now, in 2026, really a champion of international criminal law. Okay, so then we need to have a look at at one of the core principles of international criminal law, which is individual criminal responsibility. It's really important that you understand what that means. It means that the court will not look at state responsibility, will not look at whether Israel is committing genocide in Palestine, but will look at whether Benjamin Netanyahu, the president of Israel, the prime minister of Israel, is committing genocide in Palestine, or is committing a war crime in Palestine, or is committing a crime against humanity in Palestine. It looks at the individual's responsibility, not the state responsibility. The state responsibility is the duty of the International Court of Justice, which is also located in The Hague in the Netherlands. Just that distinction is really important for you to grasp. A very important quote from the Nuremberg judgment is that crimes against international law are committed by men, for example Hitler, not by abstract entities, for example let's say the Nazi Party, which is an entity. And only by punishing individuals who commit such crimes can the provisions of international law be enforced. So we have to punish individuals, not necessarily only a company or an abstract entity. Although the Nazi Party was also held accountable during actually declared illegal during the Nuremberg Tribunal. And you can find more about the individual criminal responsibility in Article 25 of the ICC statute. Then, just to briefly explain a case regarding genocide, you can have a look at the prosecutor versus John Paul Akayesu, where Akayesu was a mayor in the Taba community in Rwanda in the 1994 genocide. And he was responsible for maintaining public order at the time in that community. But of course, then unfortunately, he was part of a group of defendants who decided to commit genocide at the time. And he was then arrested and charged with genocide. And he detained, raped, and murdered Tutsis. So he was a Hutu, and back in Rwanda in 1994, it was the Hutu group who decided to murder Tutsis. So Tutsis were a minority in Rwanda at the time, and they destroyed the Tutsi group. And that's part of the definition of genocide, which we're going to have a look at shortly. Okay. And again, the court, this is now the ICTR, the International Criminal Tribunal for Rwanda, they go into what the conduct of Akayesu, the mayor, was. For example, they explain that he was a leader in the community, and then he abused that power to commit these crimes. He actively encouraged some of his friends and community members to murder Tutsis as well. So once you do that, you're complicit. You are committing the crime if you instruct your community members to commit this crime. Because what do? They believe in you. You are their leader. And now they are following your instructions to go and murder. They will also be held accountable for genocide. But you are the one who's instigating it, and you are also part of the crime of genocide. The court very importantly acknowledges this in 1994 or 1996 at the ICTR. Okay, so the ICC was established in 1998, 4 years after the massacres in Rwanda, and then 125 countries are currently states parties to the ICC statute. So you must sign and ratify the ICC statute to become a states party of the ICC statute. So Africa is a party. Prominent countries who are not part of the ICC is, for example, the USA, is, for example, China, and Russia. Then in 2002, the court opens its doors. What's important about that date is that the court cannot prosecute any crimes that were committed before that time. So that is the very important principle of nullum crimen sine lege, no crime without law. So the court isn't able to hear cases that were committed before that time. It will only hearing cases after the court opened its doors in 2002. So it's important for you just to grasp that principle applies throughout the world in any national domestic legal system, also applies at the International Criminal Court. The International Criminal Court is an interesting court because it had to bring together all the nations in the world at the Rome Conference in 1998 and had to decide what will an ICC statute look like. We have so many different legal systems. We have common law legal system in South Africa, we have a Roman Dutch law legal system, we have an English influence, etc. So how do you now bring South Africa with its own diverse legal system to this international stage, and how do we then mix South Africa's legal system with Colombia, with China, with Russia, with Australia? So they then came together and found a way to have this mix of common and civil law to eventually establish the ICC statute, which you are more than welcome to download on Google and give it a read, especially the core crimes. It's quite interesting to read those crimes and to understand what crimes, specific underlying crimes that you find under war crimes, under crime against humanity. For example, apartheid is a crime against humanity. And for example, me abducting child soldiers or children under the age of 15 during a non-international armed conflict or an international armed conflict is also a war crime. So these are very interesting statutes and provisions to read so that you can understand what international criminal law actually is. Because international criminal law is simply there to regulate the commission of crimes under international law. It's there to take a stance against these crimes because these crimes are being committed on a daily basis throughout the world. And like I said, we must take a stance against this. We must come to the table and say that no more. We've had that saying since the 1940s, but we still see these crimes being committed daily. There are 4 core crimes. They are called genocide. The genocide is the intention to destroy a protected group. The word destroy there is very important. You also, as the prosecutor, need to prove special intent. So that's also called in the law dolus specialis. So you need to prove as the prosecutor to the court that this individual, he meant to destroy that group. That was his intention. So he must also, of course, choose a certain group, and then it's classified as genocide. So the prosecution, you must prove that the defendant chose a specific group, and not just chose a group. What must he do? You must prove that he wanted to destroy that group. That's murder or rape those individuals to change the lineage of their future, of the future children, future family, etc. So you want to prove that this individual, this defendant, in his mind, he also knew that what he was doing was destroying that group. That his intent was not just to murder another human being, but that his intent was to destroy a protected group. You must prove the knowledge and the intent behind that. So simply just an individual who kills 1,000 people, orders his army to kill 1,000 people, that is not genocide. You need to prove that he killed it because he wanted to destroy that group. And the best example here to understand genocide is the 1994 Rwandan genocide, where the Hutu group decided to destroy the Tutsi group. What was the evidence? For example, they would say on the radio stations, we are going to destroy the tall trees. We're going to cut the tall trees. They were referring to Tutsis who were a bit taller than the Hutus. So that is the evidence that will be looked at by the prosecution when they look at genocide. What was said during the conflict? What evidence, tangible evidence, do we have as the prosecution to prove special intent to destroy another group? And that is one of the hurdles currently faced by the ICC in charging Benjamin Netanyahu for genocide. We haven't seen him being charged for genocide. We've seen him being charged for war crimes, and crimes against humanity. But we have not seen the charges of genocide. Now, what's going to be interesting is to see what the International Court of Justice says in the next few years when they have to determine whether Israel, not individuals, whether Israel committed a crime of genocide in Palestine. So they also then have to look at the evidence produced by South Africa, where they played videos of the army singing, we need to destroy and kill the Palestinian people, whether they can link that to Israel as a state, whether they can prove that Israel wanted to commit genocide in Palestine. So that we'll have to wait patiently for that decision to be made. That is genocide. Let me just quickly also check In terms of genocide, you have to prove as the prosecution actus reus and mens rea. So you need to prove the guilty conduct, which is actus reus, and mens rea, which is the guilty mind. Now, in terms of actus reus, a guilty act or guilty conduct, in terms of genocide, you have to you have to do something. You have to commit a crime, and this will be murder or rape. So there must be a certain guilty conduct. In this case, it is murder or rape. Various other forms of conduct, which I can also briefly read to you: killing members of a group, causing serious bodily harm, mental harm, deliberately inflicting on a group conditions of life calculated to bring about physical destruction, in whole or in part, where you cut off people's limbs and you rape the other person, imposing measures intended to prevent births within the group. These are horrible crimes. And if you can prove as the prosecution that these are some of the crimes, these are some of the conduct of the defendant, then you at least also already tick the actus reus box, the guilty conduct box. But that's not it. You also have to prove that there was mens rea on part of the defendant. And that would mean that you need to prove special intent to destroy another group. So you need to prove, in terms of Article 30 of the ICC statute, which deals with the mental element of the crimes, you need to prove that there was an intent to engage in conduct that caused a certain consequence, and this consequence was to destroy the other group. And the knowledge, you have to prove that the defendant was aware that the consequences will occur in the ordinary course, and this means that he was aware that he is going to destroy a certain group. And that's what the prosecutor will look at when they look at the crime of genocide. And so it's important that there must be the special intent to destroy another group. That is where I will stop this part of the video, and the next video I will look at the crime against humanities and the other crimes. Thank you.